Hello and welcome to The View from Mayer Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It's presented by Nicholas Robertson, the head of Mayer Brown's London employment team. This podcast is available via iTunes, YouTube and the Twitter feed Nicholas Robertson, Twitter handle @NicholasRobert11. It is also now available on Spotify, Google Play and Yahoo. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions.
Hello and welcome to the Mayer Brown Employment Law podcast, number 166. We aim to be a bastion of normality in a world which seems increasingly abnormal. We do hope everyone is staying safe and healthy out there. I did try and persuade the firm to allow me to change the music at the start to London Calling, which seems particularly relevant these days. And the gist of their response was that if I'd forgotten my telling off for my Mayer Brownies marketing idea, they'd simply resend me those messages. Hey-ho. Well, we've got three cases in this episode. The first is a case involving a costs award against a represented claimant. These are fairly unusual, and the judgment when the case went up to the AT is lengthy, very clear-cut in its finding and decisions, and so well worth discussing. Secondly, there's a case about what happens when you discover details about senior management pay on the office photocopier. And thirdly, a very important case on the enforcement of post-termination restrictive covenants. Obviously, please don't forget the podcast's available from the Mayer Brown website, iTunes, YouTube, Spotify, Yahoo, Google Play, etc., etc. And Twitter too, where we will post out the links to the cases as usual. So, first case up, Radia and Jefferies International Limited. This is an EAT decision following the appeal by Mr. Radia, or Radia, I don't know which way to say his surname. Anyway, Mr. Radia, I'm going to call him, against a decision by the Employment Tribunal to make a costs award against him. I'm sure the fact the costs in question, which were being sought by his former employer, are capped at £550,000 might explain why he was quite so keen to appeal this decision. The rules for the award of costs in an employment tribunal are set out in Rule 76.1 of the Employment Tribunal's Rules of Procedure 2013. A tribunal may make a costs order where it considers that a party or its representative has acted vexatiously, abusively, disruptively, or otherwise unreasonably in either the bringing of the proceedings or part of them, or the way the proceedings or part of them have been conducted, or that any claim or response had no reasonable prospect of success. So it's a two-stage process. First of all, has in this case, the claimant's behaviour, although of course obviously the same rules apply to respondents, has this behaviour crossed the line, or did the case have no reasonable prospects of success? If so, in that case, the tribunal may make an order. So there's then an exercise of judicial discretion as a second stage to decide whether or not it should make a costs order. In deciding whether to make a costs order, the tribunal may have regard to, in this case, the claimant's ability to pay. So what happened in this case? Well, the claimant brought three separate employment tribunal claims against the same respondent. The first of them came up whilst he was still an employee, which was for disability discrimination. He then claimed victimisation, and then, when he was dismissed, he claimed unfair dismissal and victimisation in respect to further instances of alleged misbehaviour. The tribunal found against the claimant on all his complaints, but the claimant was successful in an appeal against the dismissal of his unfair dismissal claim because there was a lack of an internal appeal process for him following his dismissal, and that part of the case is still ongoing. The costs award in question in this EAT decision, however, relates to the first of the three tribunal claims he brought: disability discrimination, disability arising from disability, a failure to comply with the duty to make reasonable adjustments, and disability-related harassment brought whilst he was still an employee. All of that was brought while he was still an employee. Tribunal recorded that it rejected all of the claims in that first claim. It acknowledged that the claimant had been legally represented throughout and that there was legal expenses insurance throughout and the insurers had supported the claim. It also acknowledged there had been no application for a strikeout or deposit orders, and the tribunal itself had not issued any costs warning to the claimant at any stage. However, the respondent had provided a costs warning letter during the course of the proceedings in which they alerted the claimant to the fact that they considered the claimant's case had no prospects of success, gave warning to the claimant that they would be seeking to recover their legal costs from him. The claimant never responded to that letter. Tribunal found that the claimant had behaved unreasonably in that he'd not told the truth and had misled the tribunal on certain matters. It also decided that the claimant had, from the outset, had no reasonable prospect of success with these claims. They acknowledged there'd been no applications for a strikeout or a deposit order, but that did not, they said, prevent them from making a costs order at the end of the case. In any event, they found that the costs warning letter sent by the respondent had made the claimant fully aware of the respondent's position on the merits of his claims. The respondent also applied for costs on the basis that having persisted with the claims in the face of the evidence was itself also unreasonable conduct, justifying the costs award. The Employment Tribunal decided that because he'd had experienced legal representation from the outset, the reasons for the subsequent failure of the claims should have been apparent to the claimant from the outset. On that basis, the tribunal took the view the claimant had no reasonable prospects of success from the beginning, the claims were unreasonably pursued from that point, and therefore all of the costs incurred by the respondent in defending the proceedings should be awarded, subject to detailed assessment and the cap that they had themselves put on the claim. Unsurprisingly, the claimant appealed to the EAT. The EAT said that the key issues would be that where the basis for the costs award is the complaints had in fact no reasonable prospect of success. First step was that in fact the case? It had no reasonable prospects of success. And secondly, if so, did the claimant in fact know or appreciate that? Or should they reasonably have known or appreciated that? The EAT commented that if it was being alleged that a claim had no reasonable prospects of success from the outset, the tribunal should start by looking at that objectively, looking at the position when the claim was begun. This would involve looking at what the complainant knew to be the case, or ought to have known. It would be important, the EAT said, that the tribunal should not be influenced by hindsight and taking into account matters that were not and could not reasonably have been known at the start of the litigation. It could, however, take into account evidence that is available to it, which casts light on what was or could reasonably be known at the start of litigation. The EAT also pointed out the fact that there are factual disputes which can only be resolved by hearing the evidence, and fact-finding does not necessarily mean that a tribunal cannot conclude that a claim had no reasonable prospects from the outset. Equally, it does not mean that a complainant could not know their claim had no reasonable prospects of success. That would still depend on what the claimant would or ought to have known were the true facts, and what view they could reasonably have taken of the prospects of the claims in the light of those facts. Here, at the EAT stage, the claimant's barrister argued that it's well recognised that discrimination rarely takes place openly and that the prospects of success are hard to assess until it has been tested in tribunal and live evidence has been given. Furthermore, the barrister said that, in essence, the claimant had lost because the tribunal preferred the employer's evidence rather than the claimant's evidence. The EAT did not agree. The EAT accepted that the tribunal were entitled to find that the complainant deliberately gave misleading or untrue evidence. Secondly, both commencing and then maintaining the claims was unreasonable conduct because the claims had no reasonable prospects of success on the basis of the claimant's knowledge or on what he should have known from the start. The EAT reiterated the tribunal's point that the respondent's failure to apply for a strikeout or a deposit order did not count against it, especially in circumstances where it set out a detailed without prejudice save as to cost letter. The EAT also noted that even if it had felt the costs order was inappropriate from the start of the litigation, it would also have found in the respondent's favour from the point at which the claimant failed to engage with the costs warning letter sent by the respondents. As the EAT put it, that letter, quote, certainly demanded a considered response, unquote. Stop. Well, the reason I wanted to mention this case is that costs award in an employment tribunal are relatively rare. Costs awards of $550,000 are rarer than hen's teeth. In the circumstances, I think this case is a bit of a wake-up call. If complainants knew, or ought to have known, the claim had no reasonable prospects of success, then tribunals can make heavy costs orders against them. Given the costs figure quoted in the tribunal judgment for the costs incurred by the respondent was in the region of £700,000, and that takes no account of management time or other expenditure incurred in the necessary defence of tribunal litigation, one can have a lot of sympathy for the employer faced with the unenviable position of paying off an unworthy claimant or incurring substantial and irrecoverable costs. It also does emphasise the importance of a carefully drafted and well thought through cost warning letter at the right point in the proceedings. It is important these are not made too aggressive or contentious, because that may undercut their usefulness. Certainly where we've done them and they've then ended up being considered by the Employment Tribunal, we've always been very relieved that we'd written them in measured and appropriate terms, rather than the sometimes more direct approach, which would be a client's first instinct. So, that's the case of Radia and Jeffries International Limited. Next up, Jagex Limited and McCambridge. This is another EAT case, and the basic facts are an employee discovers a document on the company photocopier which contains the details of the pay received by a senior member of management. He leaves it there. He tells one or more of his colleagues about the pay levels for that senior member of management. This then comes out. He is then sacked. He wins his unfair dismissal claim and breach of contract claim in front of the tribunal. Outrageous, you say. Can that possibly be right? Well, as in most cases, the devil is in the detail. So let's go back and look at those facts again and what the EAT's decision is about. The individual worked for Jagex as a lead concept artist, and he'd done so for 6 years. There had been no prior problems in his employment history with them. In August 2017, early one morning before the work had started, he found a visa application which had been left on the communal photocopier, which contained details of the salary enjoyed by the head of corporate strategy. This was a bit of a hot topic because there was some disquiet within the company about pay levels for developers as opposed to pay levels for executives. The executive salaries were not common knowledge within the company. The individual assumed that the paper would be picked up apparently, so he left it there. He told one person that day. However, a number of other people must have seen the document because, at lunchtime at an off-site, 9 of the employees attending it played a game called Guess the Pay of the Executive, in which they would name a salary figure and then be told whether the salary was higher or lower than the figure they'd guessed. The person leading that game was more senior than the claimant. The information had not come to him via the claimant, it came from someone else in the company who'd also seen the document. The claimant was not part of that group of 9 at all. The document was left there for 24 hours, and then the next day the claimant put it in the confidential waste bin. He did mention the salary details to 2 other employees on the following day. The claimant was then astonished to be taken into a disciplinary hearing on a charge of gross misconduct, which was based on his alleged unauthorised disclosure and misuse of confidential information. The Employment Tribunal was pretty scathing on the procedure adopted by the employer. Relevant documents hadn't been provided to him. He wasn't given a copy of the disciplinary policy or the investigatory notes relating to anyone else who had been spoken to. He indeed was completely unaware of the existence of the other 9 employees playing Guess the Executive's Pay. The executive who had led that particular game only got a first written warning. The company had based its case for dismissal on the unauthorised disclosure or misuse of confidential information. Clause 14 of Mr McCambridge's contract of employment had relatively standard provisions dealing with confidential information. I've certainly seen a lot worse drafted. There was a definition of confidential information which covered things like trade secrets, customer information designated as confidential information, information having commercial value or use in relation to business activities, etc. The contract said that the individual, the claimant in this case, must not, during his employment, other than in the proper performance of his duties, disclose to any third party any confidential information, but there was no express reference to the fact that salary data was to be treated as confidential information. The Employment Tribunal said that the decision-maker had come to this with a completely closed mind. There had been no attempt to analyse whether or not there had actually been a breach of the express contractual terms. There was a long litany of procedural failings, and therefore the decision fell outside the range of reasonable responses available to the employer. Indeed, they went so far as to say the company had wanted to make an example of the claimant and had been extraordinarily heavy-handed. No reasonable employer would class discussion of a colleague's salary internally as gross misconduct, they said. The tribunal stayed away from relying on the disparity of the treatment given to the other senior employee who had instigated the Guess the Executive Pay game. The test was whether the dismissal was a reasonable response to misconduct, and that, in the Employment Tribunal's eyes, it was not. The company appealed. The EAT started by considering whether or not the wrongful dismissal, i.e. the breach of contract claim, was made out, because that turned on the interpretation in Clause 14, which contained the definition and prohibition on misusing confidential information. They pointed out that salary may or may not be confidential. There's no universal answer. Here, the EAT said the tribunal had been entitled to come to the decision it did, and pointed out that apart from the HR department and one of the company's witnesses, no one else seemed to view this matter as confidential, hence the importance of the guessing game in the tribunal's decision-making. Furthermore, the manager concerned who'd left it on the printer had effectively put it into the public domain by leaving it there. On that basis, the company's appeal was unsuccessful. So having now heard the tribunal's reasoning, it certainly sounds a lot more reasonable, doesn't it? Documents finding their way to employees is something that does happen occasionally. Sometimes they're sent deliberately. Other times things are genuinely found. Here, according to the Employment Tribunal, the employer completely overreacted. As a result, they dismissed an employee who'd worked for them for 6 years, who had an unblemished record, and are now going to have to pay out notice pay and unfair dismissal compensation as a result. And of course, obviously, if you want to ensure that pay data is treated as confidential, you should be making that clear in the contract, or at least in the staff handbook or policy document. So that's the case of Jagex Limited and McCambridge. Finally, Allen and Dodd & Co. This is a Court of Appeal case that confirms that employers who sue a former employee for breach of restrictive covenants now need to think very carefully about adding in the new employer as a matter of standard practice. Since this is an issue which we were asked to advise on only last week, this is something very much front and centre of our minds at the moment. For many years, it's been pretty common practice for an employer who's lost an employee to a competitor and who considers that the ex-employee is in breach of their restrictive covenants to sue the employee and the new employer. The new employer is sued on the grounds that if the employee is in breach of the contract, then the new employer, who's on notice of the existence of the restrictive covenants, is liable for inducing the breach of contract by permitting the employee to carry on acting in breach of those restrictive covenants. Suing the new employer brings it home to the new employer that the employee is potentially going to be an expensive risk. It also increases the chances of successfully suing a defendant with deep enough pockets to pay any damages or costs award, and generally makes life much more difficult for the new employer. There may also be a benefit in joining the new employer in, as it may provide access to relevant documents through the disclosure process, say connected with the hiring process and what the employee has been up to. However, there have been several cases which indicate that suing the new employer is not as straightforward as merely ensuring that they are on notice as to the existence of the restrictive covenants. This is exemplified by the recent Court of Appeal decision in Allen and Dodd & Co. In that case, the individual, Mr. Pollock, left the firm of accountants, David Allen, and went to work at Dodd & Co. Dodd & Co. took advice from their lawyers before Mr. Pollock started with them about what to do about the 12-month restrictive covenants contained in his contract with Allen. The advice they received from the lawyers was that the covenants were probably unenforceable because they had not had any separate consideration paid for them, and that since the covenants lasted for 12 months, this is probably too long in the case of one covenant, and on balance too long in the case of the second covenant. On that basis, the advice that Dodd & Co. were given was that Mr. Pollock did not need to honour their covenants, and Dodd & Co. could permit him to go off and act contrary to them. In short, Dodd & Co. knew that there was a contract, but were advised the term was probably unenforceable. They knew there was a risk it would be enforceable, but they took him on anyway. The High Court upheld the covenants against Mr. Pollock, contrary to the lawyer's advice, but dismissed the claim against Dodd. Dodd had believed it was more likely the covenants would be unenforceable than enforceable. That was the advice they'd received. They had not been indifferent to it, nor had they turned a blind eye to the issue. Allen appealed to the Court of Appeal against the dismissal of the claim against Dodd & Co. Well, according to the Court of Appeal, previous authority on this question took the view that in order to be liable for the tort of inducing a breach of contract, you must know that you are inducing a breach of contract. Are is not the same as might be. You must actually realise that the act you are procuring will have the effect of a breach of the contract in question. Will have is not the same as might have. Court also pointed out that it is for the claimant, Allen, to prove the defendant's actual knowledge of the breach, not for the defendant, Dodd & Co., to prove an absolute belief there would be no breach. Although, and unsurprisingly, the appellant in this case pointed out this seemed to reward employers who took poor advice, or it was unfair on an employer who took advice that said there was a risk and chose not to run that risk. The court was having none of this and dismissed the appeal. The court did not engage, or not give a view, I should say, with what would happen if the employer's advice had been, it's arguable they're unenforceable. As I say, the advice here was it was probably unenforceable and probably was good enough to get Dodd & Co. off the hook. Well, I think the upshot of this is to make it much more problematic for the employer, in this case the old employer, to sue the new employer for breach of restrictive covenants. If there is some suggestion the covenants are unenforceable, then the new employer will almost certainly point to legal advice saying they're entitled to act in the way that they are doing. I think, therefore, we're going to see fewer cases where the old employer will want the complexity of trying to prove that the new employer was aware all along that he was acting in breach of contract, and therefore the test for inducement to breach contract is made out. I think it was important here that Dodd had clearly taken advice carefully. When one part of the factual information they provided to their lawyers was shown to be incorrect, they went back to check with them to see whether it made any change to the overall advice. In that context, it was going to be pretty hard to say they were indifferent to the risk. I do wonder what a court would do with an employer who did not take advice at all, but based on their own knowledge decided that covenants would probably be unenforceable. What would happen if they did that on the basis of they weren't covenants that were standard for the industry, for example? Equally, and I'm sure many of us have had this experience, a client rings up for a reaction to a particular covenant and says, can you just have a quick conversation, 5-10 minute conversation about it? Will that be enough? It will all be fact specific, of course, and I'm sure that some new employers, if they are indemnifying the employee joining, may take the view they don't want to have to start waiving their legally privileged advice. So I think it's going to be a balancing exercise for the old employer rather than an automatic decision to add the new employer to the claim. So that's the end of the 3 cases. I did just want to say a few words about the podcast series while we're on this period of enforced working from home. Yes, okay, that's my next call coming up. Anyway, I had... What I'm planning on doing is keeping these going throughout and probably doing more of them, but maybe doing just 1 or 2 cases per episode. Part of the thinking when I did the podcast series originally was that a lot of people have a commute to work and the podcast might fit very nicely into that part of their day. If we're not commuting to work, then that's no longer the option. So I thought if I do more podcasts but limit them to 1 or 2 cases rather than the standard 3, it may be easier for people to find a spare 10 minutes to sit and listen to my dulcet or not so dulcet tones. Also, given that I'm recording this from my house here in Woking, I do want to see if I can persuade the firm to rename it the Woking Classes. Anyway, we'll see how we get on with that idea. Most importantly of all, please stay safe, everyone, and look forward to speaking again soon. Cheers.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions or want to know how to claim continuing education credits, please email Nick at nrobertson@mayorbrown.com. Thank you for listening to the podcast.